Hello, everyone. I think we're going to go ahead and get started. My name is Jessica Enix, and I'm with the ASA staff. I would like to welcome you to today's ASA webinar, Proposed Wage and Hour Regulations. Before we begin, I'd like to review a few points of protocol so that you get the most out of your webinar experience. Remember, you are listening to the webinar via a conference service. If you are disconnected, repeat the steps that were given to you by the GoToWebinar registration email. In order to reduce background noise, please be aware that all participant lines are muted throughout the webinar until the Q&A section at the end of the webinar. If you have any questions throughout the presentation, please type them in the Q&A panel located at the right-hand side of your screen. The presenter will respond to all questions at the end of the presentation. Please note today's program is being recorded. It is now my pleasure to introduce our presenter, Ms. Jamie Hasey. Ms. Jamie Hasey is Vice President with Sesco Management Consultants, Bristol, Tennessee, and Richmond, Virginia. She graduated from East Tennessee State University with a BBA in Human Resource Management. Her professional affiliations include Delta Sigma Pi, a professional business fraternity, the Society for Human Resource Management, and various state chambers of commerce. Jamie is a generalist consultant in all areas of human resource management with specialties in affirmative action, policy development, and hour accounting, employment regulation compliance, training and development, compensation and performance management systems, employee satisfaction assessments, executive screening and placement, and general human resources consulting. The variety of client engagements and daily interactions over the course of Jamie's career enables her to provide practical and helpful advice and support. She regularly conducts management training programs for clients and serves as guest speakers for state and national associations and chambers of commerce. Jamie is a certified trainer for Vital Learning Corporation and Sesco Leadership Institute. Ladies and gentlemen, please welcome Jamie Hasey.
Thank you, Jessica, and thank you to the participants today for spending their afternoon or morning, depending on what coast you may be on, with us to talk about the upcoming overtime exemption changes and how those may affect your organization. Just a little bit of background about Sesco. We are based out of Bristol, Tennessee, but I run the Southeast Division out of Richmond, Virginia. But we do have clients across the country, and we've been very fortunate to partner with associations such as ASA to provide ongoing consulting and support, HR support, to its valued members. So we have a very long and rich history in wage and hour accounting, dealing with minimum wage, overtime, exemptions from overtime. And in fact, we're the oldest consulting firm in the country. We've been in business for 70 years. So it is a pleasure to be with you all this afternoon. We do have quite a bit to cover. I'd like to cover kind of what the regulation as it stands today looks like, and then we'll dive into what we anticipate the salaried exemptions changing to, particularly with the salary threshold. And I really want to look at why is this important for any organization. You know, there's so much liability that can be involved with misclassification of individuals from a compensation perspective. So as we go through this content, I'll point out things where we see in our audits and dealing with our investigators, you know, where are areas of liability for large and small companies that we see. So we'll talk about the exemptions, we'll talk about the proposed exemptions, and also some tips and compliance aspects that we recommend you do as an employer just to negate any sort of liability there. So a lot of information to cover. As Jessica said, what I'd like to do is if you have questions throughout the session, there is a chat feature on your right-hand box. So feel free that as they come up throughout the session. I will address those. I'll read the question out loud and then provide you with my response. If for whatever reason the chat feature does not work, we may unmute people's lines at the very end, but we would only do that if you use the feature to raise your hand. So let's jump in. Like I said, a lot to cover, and I want to make sure that we're utilizing our time appropriately. So the Fair Labor Standards Act, FLSA, this is the law, federal law, that requires or designates rather how most employees must be paid. So at the very minimum, everybody is entitled to minimum wage for all hours worked. And minimum wage from a federal perspective is $7.25. Now, it is important to note that many localities, many states have varying minimum wages. Also, in the contracting industry, if you are a federal contractor or a subcontractor, there is now a federal contractor minimum wage, and I've got a slide on that we'll cover. So we have to at least make minimum wage for all hours worked. We also have to be paid an overtime premium at time and 1/2 the regular rate of pay for all hours worked in excess of 40. So the federal government says that our standard work week is 40 hours. Anything over 40 hours is an overtime premium. So if you've got an individual who's making $15 an hour, the overtime is calculated at 1.5 times the 15 for any hours that exceed 40. Now, the other piece to the FLSA is that all individuals must keep what we call a true and accurate time card, clocking in and out for meals, when they start the day, when they end the day. Doesn't matter how that time is tracked, whether it is electronically, whether it is a physical hard piece of paper, whether they write it on a napkin. As long as it is a true and accurate reflection of their hours worked and they sign off on it, that's sufficient to meet the Fair Labor Standards Act. So they've got to have minimum wage, overtime, and keep a time card. Or we look at, may they be exempt from overtime, from both the minimum wage and the overtime piece. And that's what we call our white-collar exemptions. And there are different versions of the white-collar exemptions, or different types of white-collar exemptions, rather, that we can look at applying. But it's important for us to note that as we talk through what the proposed regulations are, the last time that the federal government revised any of these white-collar exemptions was back in 2004. So it's been 12 years. Okay, so it's been a while, and we've got some work to do. Executive Order 13658. The President issued an updated federal minimum wage of $10.15 in the calendar year 2016 for contractors. This is applicable if you have any contract that is subject to the Service Contract Act or the Davis-Bacon Act. So if you all are out there bidding and we're getting, bids of over, $500,000 and we're taking them, we're going to have to comply with the 1015. Now, most contractors are already doing that. So if you're already complying with the 1015 minimum wage, you're good to go. But if you aren't, make sure that you're complying with that aspect. Also, part of that executive order included if solicitation was issued on or after January 1 of 2015. So if you solicited out a bid or you were issued a contract on or after January 1 of 2015, then you need to comply with the 1015. So check your contracts to determine if they're applicable. If you have questions about your contract or you're not sure what to look for in your contract, feel free to send it to me or to any other consultant at SESCO, and we will make sure that you are guided in the right direction. Okay, but just remember, federal minimum wage for contractors is $10.15 an hour. All right, so what's going on? You may have heard a lot about these overtime exemptions changing, and we're still waiting on final word, where we anticipate that we'll get that this month. There's been proposed regulations, and I'll cover what those are. But back in March of 2014, President Obama issued a memorandum to the Secretary of Labor, basically stating that we need to update and modernize overtime regulations. That you know, the white-collar exemptions haven't kept up with modern-day society. We're outdated. A lot of folks are working a ton of hours, not earning overtime, and they're truly not doing management-type duties or, you know, really having high-level decision-making power. So he issued that memo and pretty much directed the Department of Labor to review and update all of the exemptions for the white-collar folks. So back in June of this past year, 2015, we finally got a 295-page notice of proposed rulemaking. And that was published, and the public had up until, I believe it was September 5th, at the close of business to comment on that. SASCO, of course, reviewed it, commented. Attorneys, general public, individuals had the opportunity to look at what the Department of Labor was saying and give their feedback on that. So it addressed and explained their plan of action to accomplish the President's directive. And please note that, again, it was a proposed rule, so they had to publish it in the Federal Register. And so we expect that, like I said, the final rule to be published May of this year. They had said anywhere between April or May. The original intent was, you know, June or July, but we're hearing word out of Washington that they've kind of pushed that up a little bit to try to get it in before the summer. Now, once they publish that final rule, generally the rule becomes effective no less than 30 days after the publication, but could be as much as 120 days. We anticipate that they will give you 60, no more than 90 days to get compliant. Okay, so that means if you have salaried individuals, particularly managers, office workers, that sort of thing, we've got some work to do. We need to look at them, look at how many hours they're working, look at do they even classify for exemptions, and get some things in place to make sure that you're compliant. So here's our practical impact. Basically, what these revisions will do is allow for more employees to be entitled to overtime. The Department of Labor estimates that 4.7 million employees will now be eligible to receive overtime premium payments, which is a ton of folks. That also means that if you have a large organization with a lot of people on a salary, that means, you know, we've got a budget for that increase. Or manage the hours down. And there are a lot of ways we can get creative with compliant pay plans. But 4.7 million employees is a very large number that is now coming in and eligible to earn overtime. We also anticipate that there will be additional or an increase in overtime claims and lawsuits. So as I mentioned, the last time that they reviewed or revised the exemptions was 2004. And between 2004 to 2007, the lawsuits or new FLSA suits rose 40%, and there was a 98% increase in collective action. So do not be surprised that with these changes come anonymous complaints to the Department of Labor, Wage and Hour Division. My name is Johnny, and I don't think I'm being paid appropriately. I'm working 60 hours a week, and I'm on a straight salary. You know, the employees have a legal right to make an anonymous complaint to your state or federal Wage and Hour Division. So we do anticipate an increase in random audits, an increase in overtime claims and lawsuits. And so our goal is to collaborate with you all and to help you all get compliant so that if we have to defend a wrong claim, that we're in a great position to do so because we know that we've complied with the law. Okay, so let's cover what the white-collar exemptions are. So the FLSA provides for roughly 40 different exemptions from overtime. Some are full exemptions, some are partial exemptions, and some are industry specific. But what applies to all employers, large or small, in all industries are what we call our white-collar exemptions. And this means that the individuals are exempt from both minimum wage and overtime requirements, and also these people are not required to maintain a time card. Okay. So the first one, and probably the most common and easiest to apply, is what we call the executive exemption. These individuals must be compensated on a salary of no less than $4.55 per week, guaranteed. The individual must be managing a department or a division of the organization, and they must have direct supervision over 2 or more full-time employees. They must also be primarily engaged in managerial duties at least 51% of their time. They have to be directing the work, doing screening, hiring, firing, performance management, so on and so forth. So the executive exemption is probably the easiest for us to review, look at a position and determine, does this individual or does this position meet the exemption test? The next one that we would look at if they don't have individuals that they directly manage would be our administrative exemption. Again, a guaranteed salary of $4.55 per week. They must be an office worker or doing non-manual labor. And they have to be primarily exercising independent discretion and judgment for matters of significance. Now, that definition right there is fairly vague, but case studies, interpretations from the Wage and Hour Division basically say an administrative exempt individual really needs to be exercising high-level decision-making power or be able to exercise their opinion and recommendation for high-level decisions for matters of significance. So typically, if you have somebody that's administrative exempt, this is your one-person accounting office. That may be a CPA, that may be making high-level budget decisions, capital expenditures, those sort of things. But they have to be really making high-level decisions that would affect the overall business operations of the organization. Anything that would be routine, repetitive in nature, such as data entry, filing, basic administrative type work, would negate our ability to apply this exemption. Okay, so you've got your executive, you've got your administrative. Those are probably your two most common for this industry, as well as office type or field type staff. You have your professional exemption. That could be a salary basis of $4.55 or a fee basis no less than $4.55 per week. They have to have obtained prolonged course of instruction in a field of science or learning, so basically a master's degree level in science or learning. Or a PhD, and they have to be utilizing that knowledge in a field of science or learning for their primary duty. So these are your doctors, your lawyers, your nurses, your professors or teachers. So there's a professional exemption there. It's also your CPA if they have a true CPA designation. Okay. We also look at highly skilled computer employees. These folks have to be compensated on a salary or fee basis as well, of $4.55. These are not your general IT folks. That is a common misapplication and a common misconception when folks interpret these white-collar exemptions. The computer employee exemption is truly intended for somebody that is developing programs like a Microsoft Office or Word or Excel program, that's writing internet code, that's doing high-level technical work. Often we see in organizations folks try to apply the computer exemption for their general computer or help desk support individual who is maintaining the website or generating logins, setting up the hardware systems. That's not going to meet the tests. So you have to have extremely high-level technical programming skill and be primarily engaged in those type of duties to meet the highly skilled computer employee exemption. You have your outside sales exemption. There is no salary or fee requirement there, but these folks need to be primarily engaged in sales or negotiation of contracts or obtaining bids for contracts, but they have to be spending the majority of their time away from the physical office. So if you have somebody that is sitting in the office the majority of the work week and only goes out 2 days a week, that's probably not going to suffice the duties tests. But if you have somebody that really is out there hitting the pavement, knocking on doors, meeting with businesses or organizations that are selling your services, drafting up those contracts and negotiating the contracts, they would be considered outside sales. And again, exempt from overtime and that timekeeping requirement. Then you also have highly compensated employees. That is somebody that earns over $100,000 in guaranteed salary that is performing any of the duties covered under the other exemptions. Okay, so a lot to kind of think about. And our primary goal is to look at, one, do we have anybody currently compensated on a salary basis in our organization? And two, where might they fit in any of these 6 white-collar exemptions, if any? And they may not fit in any, and then we have to look at, okay, how do we handle them? But as the law stands today, what I just covered in terms of executive, administrative, professional, computer, sales, and highly compensated is how the law is written. The $455 guaranteed per week, and it's a duties test. The 3 tests must be met to qualify for the exemption. So it's kind of an all or nothing mentality when the Department of Labor reviews these things. They have to meet the salary basis and the salary level, at least the minimum amount, and then they're going to explore the duties. And again, if they're meeting 1 or 2 out of the 3, it's not going to work. They have to meet all 3 in order to even apply the exemption. So the white-collar exemption, the salary level is the amount of salary paid, which must meet a minimum specified amount. So with the proposed regulations and with the directive issued by the president, there were some comments basically that said, they want to simplify the exemptions. Looking at the salary level is a ready method of screening out obviously non-exempt employees. It can be the single best test of an exemption status, so on and so forth. So here is what they are proposing from a salary threshold. So remember, the current law states $455 guaranteed a week. The Department of Labor is proposing a new salary threshold of a guarantee of $970 per week. So when we look at annual current compared to annual proposed, it's a significant increase. It's more than 2 times the current salary basis. And it's the 40th percentile of weekly earnings for full-time salaried workers nationwide. And if we compare that to 2004, which looked at the 20th percentile of salaried employees. So it's a significant threshold. Now, you all may be sitting on the line thinking, Jamie, I've got nobody that's making a salary that's less than $50,400 that's in a managerial type role or that may qualify under one of the other exemptions, and that's great. But for other organizations, you may have somebody that's a mid-level manager that is managing but making $40,000, $45,000 depending on where your office is located or where your your folks live. So it's going to affect people and organizations in different ways, but please know that the guaranteed salary is proposed to be $970 per week. It may be less than that, but we need to think about $970 or the proposal of $970 and anticipate that. As I mentioned, the current salary threshold or salary level for a highly compensated individual is $100,000 annually. The new proposed salary threshold for a highly compensated individual would be $122,148. Okay, so that would also increase. So the Department of Labor is also proposing to include a mechanism to automatically update the salary and compensation thresholds annually using some sort of fixed percentile of wages based on Consumer Price Index. So it's important to note that, yes, we may be taking this big jump in 2016 based on salary threshold, but it's only going to continue to increase if they include this automatic update mechanism in the final regulations. So that means, you know, in addition to merit pay, if we're compensating them on performance, you also may have to continue to increase just to keep up with the salary threshold to avoid the overtime payment. Outside sales exemption, as I mentioned, had no salary basis. So right now we don't think that anything will change particularly with that exemption. As I mentioned, inside sales, there is the DOL really had representatives or employer representatives arguing the difference between inside and outside sales and the application of the exemption. So we will keep our eyes on that as the final regs come through. Highly skilled computer employee, again, current regs say that it's got to be paid at least $4.55, or we can pay them at a rate no less than $27.63 an hour. So they would also have to comply with the $9.70 per week. So that's something to think about. So what does not change right now? As it stands today, everything is fine. New salary levels haven't hit, final regs haven't hit. But I do want you all to start thinking about who is paid on a salary and where would they fall within that $4.55 to $9.70 guaranteed per week. Because those are the folks that we need to start looking at possibly having to adjust or put on a different compensation plan as we move forward in the next 2 months. The DOL is also considering whether revisions to the duties test are necessary. So again, you know, for example, the executive exemption, primarily managing. Typically, the courts have ruled, and the Wage and Hour Department has, you know, interpreted 51% of their time would be primary. But the Department of Labor also has the ability, as they revise these exemptions, to put more specific language in the exemptions with regard to duties. So we're not sure whether they will revise the duties test or leave the duties alone and focus solely on the salary, but I would not be surprised if they make minor tweaks to the duties test. Also in the Federal Register or the Code of Federal Regulations, which is a very thick book with teeny tiny print, with these exemptions, typically the Department of Labor will say these positions generally qualify under this exemption. So we anticipate, or the Department of Labor rather, is considering including additional examples of occupations when folks are administering the exemptions, particularly for computer-related exemptions, because that category has been left open to a lot of interpretation and misclassification of workers. The DOL is also considering maybe allowing non-discretionary bonuses and incentive payments to satisfy some portion of the standard salary test. So you may have foremen, you may have project managers that are paid a smaller salary, but maybe they get a bonus if the job finishes up under budget and on time. So they're determining whether we allow the employer to apply part of a bonus to meet that salary test, that 970 that's proposed. So that we will keep our eyes peeled on that. For a highly compensated employee, may be allowed to make a catch-up payment at or shortly after the end of the year to reach the compensation requirement. The DOL rejected that idea for other exemptions. So we will let you know as soon as the final regs hit what exactly is included and what is not included. It is also important to note that they are not considering including discretionary bonuses, lodging, or board, room and board, to help meet that salary threshold. So if you've got a project that's working outside of town, and the folks are staying and the company is paying for the hotel and all of that, we would not be able to include that in their guaranteed weekly salary. So ultimately, who's going to be impacted? It's going to impact pretty much every industry, but typically we'll see education, health services, retail, trade professionals, and hospitality industries ultimately impacted. Folks that operate in the South or in rural areas may feel that salary level increase most acutely due to cost of living as well. So everybody's going to be impacted, whether you're a $500,000 company or a $15 million company. So it's important to start thinking ahead and planning. I don't want you to panic on me just yet. I do want you to kind of wait until the final regulations hit before we take any sort of action. But I want us to really start thinking about who may be impacted that's in your organization. And that is something that you can call me up and say, Jamie, I've got these 4 people. I'm a little worried. How do I handle it? And we can kind of come up with some optional pay plans for you all to consider. So we want to self-audit, identify those that may be affected. You're also going to want to think about budgetary effects and workforce effects, job compensation restructuring. Can we afford to pay them overtime? Can we afford to operate with them not working 40 hours? We also have to look at timekeeping mechanisms. So if you've got folks on a salary basis that are not used to keeping a time card, that may now have to keep all of their time, we've got to get timesheets, or they need to punch in, or whatever your method of timekeeping is. We also have to explore that piece. We also have to look at the effective mixed classification position. Do we have managerial positions that have both non-exempt and exempt employees? So there's a lot of things to consider. There are a lot of creative ways to be compliant, but also remaining operational. And you also want to look at your analysis of overtime hours. So if you've got folks that are on salary, start looking at how much time are they truly working. I know a lot of them may not be keeping a time card, but in general, the managers or you all as business owners should have a pretty decent idea of how much time they're really spending on the projects or at work. So start looking at that. If they're on salary and they're not working over 40 hours, it's a moot point. Where we get into muddy waters is when, A, they're not going to meet the new salary test and they're consistently working over 40 hours. So we have to look at that. I also do want to note that it is a sensitive conversation that we would need to have when you have somebody that may be currently exempt that may have to transition to an hourly position and earning overtime, or we adjust their pay plan. Now, the good thing is we do have kind of a golden opportunity to analyze and correct any misclassification. So if you have folks that are currently misclassified that we've kind of just been biding our time with, this is a perfect opportunity for us to say, well, the law made me change it. And to play it off that way so that, one, we don't, throw any red flags, but two, we're getting compliant. And you should consider a professional audit or analysis and how those folks are going to affect your workplace. You want to look at what we call hidden overtime, how much time is being done off the clock. Technology is great these days, but with the iPhones and the iPads or the Androids and tablets, folks are often, going home and doing more work or taking phone calls or responding to emails, and, all of that is compensable time. So we have to think about the hidden overtime cost that we may not necessarily always see on the time card. We also want to analyze the impact of reclassification on payroll, budget, timekeeping systems, and look at possibly pay and or work hour restructuring for converted employees. Ultimately, we want you all to be compliant. If we get into kind of the ins and outs of why the wage and hour compliance piece is important, it's because if you have an on-site audit by an investigator, the wage and hour investigator will come on and request 2 years of the last payrolls. Payrolls, a list of all employees, whether they're current or they've been terminated over the last 2 years. They will interview your staff, ask them about their hours of work, how they're compensated, and then they will come up with a calculation if they think anybody has been misclassified or overtime was not paid correctly or meal periods were cut short and not compensated for. There's a lot of liability involved with wage and hour if it's not done properly. And, compensation is your number one controllable cost for an organization. So we want to make sure that you're compliant. And if you're not, let's get you there. It's very important that we get you there and we get you in the right direction so that we negate any of that liability moving forward. One of the most common questions that we've gotten over the last year and a half as this overtime exemption rule has kind of been lingering is, can we keep paying unaffected employees a salary? Yes. Yes, you can, but it's important to note all non-exempt employees are legally required to keep a time card and pay overtime. So they've got to keep that time card, even if the position is scheduled for less than 40 hours. Are we confident that the employee is not performing duties working outside of the organization? Like I said, that hidden overtime. If the employee is kept at status quo, they're paying their current salary without any deductions for missed work, does our budget allow for additional overtime expense? Okay, that's something to consider. And you may look at an optional pay plan of what I call a fluctuating work week. That, in essence, is a salary basis that covers all time worked. But you still pay overtime. It's at a half rate versus a 1.5 rate. So it is compliant. It has to be structured properly. The individual has to sign a pay plan agreement, but it is a way of providing overtime, saving the company money, but still staying compliant with the regulation. Things that I want you all to remember. No employer is guaranteed or required to guarantee overtime work. No employer is required to pay an employee more compensation as a non-exempt employee than what they would have been earning as a salaried exempt employee. The changes to exemptions don't necessarily have to affect your labor cost. You can back into an hourly rate, but you must take into account overtime and hidden costs. So as a legal matter, you can configure the hourly wage and anticipated overtime based on kind of what they've historically done to ensure that we're making roughly the same amount of money as they were paid on a salary basis prior. But again, don't do that on your own. Pick up the phone and call Sesco and let us vet what you're trying to do to make sure that it is compliant and that it's done correctly. Or again, you have the option of doing a fluctuating work week. So I also want you all to remember that as these changes come, be prepared for issues with morale and perception. Formally exempt employees or salaried individuals will often see as a reclassification as a quote-unquote demotion. Why do I have to keep a time card now? I've never had to do it before. Now you're treating me as a normal employee when I'm a manager. So, it is, like I said, a sensitive conversation that we need to have. You may resent, or folks may resent being classified as non-exempt and resist keeping those time cards to accumulate hidden overtime. And we also need to plan for how this reclassification needs to be communicated to your current staff, or particularly the affected employees. As I mentioned, it is a golden opportunity for us to use the change in the law as kind of our basis, but we have to explain to them, what that truly means from their personal compensation as well as from an organizational perspective. Okay, so a lot to consider, a lot to think about. If you have newly classified non-exempt employees, they will have to be trained or verbally coached on the timekeeping record and procedures, complying with your meal and rest break requirements. As a reminder, federal law states that in order for us to not compensate somebody for a meal period, an unpaid meal period or a break period, that time has to be at least 30 minutes or longer in duration where the employee performs no work. So hypothetically speaking, if I have a short staff or short shift that day and I run out and grab a sandwich and I come back to my desk and I'm eating that at my desk, or I'm sitting in my car eating my lunch and the phone rings and it's work related and I pick it up, guess what? I'm back on the time clock. So those are the things that from an office manager or an HR perspective we have to be looking at to make sure that folks are complying with whatever your employer policy is with regards to meal and rest breaks. Okay. We will also have to train them on restrictions about working outside normal work hours. Travel time often can be compensable, and so depending on where they're traveling to, how is that scheduled, and any other compensable time issues, all of that has to be communicated with the employee as well as, their managers. If it is an assistant manager or assistant foreman, who's in charge of reviewing that and who's in charge of training them on how to handle those things. We will also have to look at deductions for partial day absences. A question that we get quite often is, do our policies need to be updated and rewritten? Probably not a bad idea to have them reviewed or challenged, but let's wait until we get the final regulations in place before we start changing policy or procedure, okay? So plan now. Look at salaried, look at, do they currently meet the exemption or are they currently misclassified already? We may want to move some folks around, decreasing or depressing the hourly rate for the new pay plan. Not my favorite idea, but some folks have challenged reducing or adjusting benefits to make up for the additional monies lost in the overtime or projected overtime that they will pay out. You may also want to challenge annual bonuses or other compensation that may be provided, because it's important to note that if you have a non-exempt individual who is eligible for overtime, giving them a bonus that is tied to performance, it must be included in the overtime calculation. So that is also an area that is full of liability. Or do we look at putting folks on fluctuating work week? So I want to kind of cover this a little bit more in depth so that you get a better picture of what fluctuating work week looks like. It is an approved pay plan by the Wage and Hour Division. Basically, the way that it works is our weekly gross wages will fluctuate according to the number of hours that the individual truly works. As I stated, there has to be a signed agreement in place with the employee, but there are advantages to using this method of payment. So folks, some employees love this because I'm guaranteed a base salary. So I know from a living standpoint, from a paying my bills standpoint, how much money guaranteed each week that will be coming in. So my base salary will not fluctuate nearly as much as it would if I were being compensated on an hourly wage rate. So I get a guaranteed weekly base salary regardless of the number of hours that I work. And then the overtime is calculated based on my straight time hours. So the more overtime that I work, in essence, the regular rate of pay and overtime rate decreases. So if you've got somebody that's working 45 hours one week, and when I take that salary and divide it out by 45 hours, that gives you a higher wage rate, whereas the next week I may work 60 hours, and I take that same salary and divide it out by 60. The following week, my regular rate of pay for that week has decreased compared to the week before. So I give this example using very simple numbers, looking at an employee that would be paid, in theory, $10 an hour, working 45 or 55 hours per week, using a fluctuating work week method compared to regular overtime. So again, you can use this for somebody that may be currently misclassified, or somebody that we can't meet the 970 a week, or they don't meet the duties test, and we want to reduce our overtime calculation. So using a fluctuating work week, you could hypothetically, for this person, give them a guaranteed salary of $450 a week. And you divide that by the total number of hours that they work. So in this example, 55 hours, which gives us a regular rate of pay of $8.18 per hour. So to calculate the overtime, I take that $8.18 and divide it by 2. So this is what we call our half-time rate of $4.09. And I take that $4.09 and I multiply that by the overtime hours, the 15 hours, because remember, anything over 40 hours in a work week is considered overtime. And I get $61.36 due in overtime. So for that week, for that employee on a fluctuating work week method of payment, they're getting compensated a total of $511.36. Now, taking that exact same scenario, looking at using regular overtime calculations, you take somebody that's making $10 an hour times 40 at regular hours, totals $400. Then I take their overtime rate, which is 1.5 times the $10, so $15 per hour for overtime, times the 15 hours that they worked, is $225. So total compensation for that week would be $625. So you can see, comparing the two, that if you have somebody on fluctuating work week, you're saving money in overtime. They're getting the benefit of still staying on a salary. We're compliant with the wage and hour division, and it helps us from a budget perspective. So this is a good option. It is not a fix-all for everything. Some organizations love it. Some organizations don't want to use it. But it is an option to consider as we work through some of these overtime exemption challenges. I also would like to cover just some basic common wage and hour violations that we see. SESCO does a lot of Fair Labor Standards Act, wage and hour accounting, auditing, and again, if you haven't had an on-site compliance assessment, it's probably a good idea to have one of those done. As I mentioned, it's a huge liability. You never want the Wage and Hour Division to come on site and do a full-blown investigation and look back at 2 years. Payroll, timekeeping, terminated and current employees. And, if you've got somebody that was misclassified, guess what? We're going to cut a check to those folks if we weren't doing something correctly, whether it was willful or not. So some of the things that we see through our dealings with wage and hour, or things that they're looking for, are first and foremost misclassifying non-exempt employees as exempt. Challenge your office management staff, change your computer professional exemptions. Know who's on salary, who's working more than 40 hours a week, who's getting bonuses that are on salary, and work with SESCO to kind of fix that. We also see a lot of folks not know what is and what isn't considered work. As I mentioned, payroll is probably one of your easiest controllable costs and your number one controllable cost. So watch the early and late clock-ins and clock-outs. Typically, we recommend that employees don't clock in any more than 7 minutes early. If depending on how your timekeeping system is set up, you could be rounding back or rounding forward to the nearest quarter hour, which is a compliant pay plan, or a compliant method rather of rounding. You may be paying directly to the minute, but riding the clock, so to speak, can add up significantly by the end of the week when it comes to overtime. So the managers truly need to be watching the time cards, who's clocking in early, who's staying late, or who's marking their time cards early or late, because that could be a significant cost savings if we can get that under control. You also have to watch working off the clock. As I mentioned, particularly for hourly or even salaried folks, especially if they're misclassified, taking home work, doing work after hours is compensable time. The wage and hour of the Department of Labor, the way that the regulation is written is work, the employee is considered engaged in work if they are suffering or permitted to work, and it's for the benefit of the organization. So, if I'm sitting at home at 9 o'clock at night, reviewing contracts or finalizing bids and shooting off emails, that's compensable time. And if that person is salaried, and guess what, with these overtime exemption changes coming, they can no longer be there on salary, that means I'm going to have to pay them for that hours. Even if it's unauthorized overtime and they work it, we still legally have to pay it. So it becomes a management issue. We have to get that working off the clock under wraps. As I mentioned, lunch and rest breaks. If you're not going to pay for a meal period, it's got to be at least 30 minutes or longer. Make sure that if you have an employee handbook, which fingers crossed we all do, there needs to be some sort of policy in place that talks about what the employees are able to take, whether it's 30 minutes, a full hour, 45 minutes. And the managers and supervisors need to follow the policy and hold them accountable for that. Travel time may or may not be compensable. It depends on if it's an overnight trip, when the travel fell in terms of, was it during their normally scheduled, was it outside of their normal schedule? It really is a case-by-case scenario. So if you have questions on travel time or want to dig into that further, please give us a call. We'd be happy to review those different scenarios with you and what is compensable. But I will remind you that travel from the employee's home to the office or to the is not compensable, but travel between offices or between work sites is compensable. So my normal home to work travel, you don't have to pay me for, but if I go to the office first and then I leave the main office and travel out to a satellite work site, the travel time between me leaving the Cesco office to the work site is compensable. So those things you need to look at and make sure that we're handling appropriately. You also have to look at on-call time because often that can be misclassified as well or not compensated correctly. There are two different types of on-call time. The first being engaged to be waiting, and the second being waiting to be engaged. So when we have engaged to be waiting, you have the employee that is sitting by the phone and can't leave their house, and has that phone or that tablet ready there, and they're just hanging out, and they are sitting around waiting for you to say, oh, we need you to come in or we need you to handle this. That would be pretty much compensable the entire time that they are restricted or required to be sitting at home waiting for that phone call. Whereas I've got waiting to be engaged, meaning you may say, Jamie, just carry your work phone with you. You're going to be on call, and you don't have to do anything until the phone rings. Okay, so that is waiting to be engaged, meaning that the only time you compensate me for being on call in that scenario would be when the phone rings and I pick it up. As long as I'm free to move, free to go wherever, whenever I want, you don't pay me until I actually engage in the work. So those are the two types of on-call time, and make sure that we know, and our payroll and our office folks, whoever may be handling the payroll or dealing with the time cards, know what is and what is not considered work. Trap number 3 would be not paying for off-the-clock working hours. As I mentioned, even unauthorized overtime must still be paid. And you've got to look at short clocks, particularly for meal periods. If I'm taking a 15, 20-minute meal break, that is also compensable time. So make sure that we're covering that. Trap number 4 would be not calculating the employee's regular rates properly. If you're using fluctuating work week, remember it is half-time rate for overtime. If you are paying either an hourly employee or a salaried non-exempt employee an incentive or a bonus based on performance, it must be included in the overtime calculation. Okay, that is a common misconception or a common practice that most folks are not aware of. And it becomes a different calculation. So we've got staff recommendations I'm happy to send to you all if you need it on how that works. And as a reminder, if you move somebody to the fluctuating work week, you can no longer include a bonus or incentive along with that method of payment. So that is one downside to using fluctuating work week, is that you can't give them a bonus or incentive tied to performance. Trap number 5 is making improper pay deductions. Federal law and most state laws state that we can not deduct anything from an employee's paycheck without prior written authorization to do so. Things like uniforms, things like equipment, things like damages to our property or our equipment cannot be deducted using a blanket authorization. There has to be a proper signed agreement. It needs to be specific as to, I, Jamie Hasty, agree to have you deduct blank amount from my paycheck for the next 3 pay cycles for this reason. It's got to be extremely specific. So if you're using a blanket wage deduction authorization agreement, pop it over to us, let's review it and make sure that we get you something that's more specific to meet the wage and hour requirements. You also would not be able to do deductions from fluctuating work week method of payment if they hypothetically miss work. So let's just say, scheduled work 50 hours that week and I called out sick 2 days that week, and let's just also hypothetically that, I don't have any more paid sick time available to me. You cannot deduct from that guarantee because, remember, it's a guarantee regardless of the number of hours that I work. So don't make improper pay deductions, and also don't improperly deduct from guaranteed salary exempt folks either. If there is incomplete record keeping, as a reminder, everybody has to keep a time card unless they are truly and fully exempt under one of the white-collar exemptions. So, again, Wage and Hour doesn't care how you maintain their time records or how they track their time. It just needs to be true and accurate. So, it's also important to note that they need to really show when they come in the morning, when they leave for lunch, when they come back from lunch or dinner, whatever their schedule is, and when they leave for the day. So there should be hypothetically four punches or 4 times shown on their timesheet every day. Wage and Hour does not like to see a general, on Monday I worked a total of 8 hours. Or they also don't like to see, Monday through Friday, 8 to 5, 8 to 5, consistent, because we know that not everybody shows up at work promptly at 8 and starts work promptly at 8. So even if they're keeping a handwritten time card, is it 8:05 to 5:35-ish? So it needs to kind of be true and accurate. I would also suggest that the employees, if you can, have them sign off on their time card. That shows or acknowledges that they've reviewed it and it is a true and accurate statement. With employee signatures on the time card, it helps us defend any sort of wage and hour suit if the employee is interviewed or if the employee makes a complaint saying, I'm working all of these extra hours, or I don't feel like they've paid me for the extra hours. We can pull their time records and show to the wage and hour division that here's the hours that they did work, and here's their signature acknowledging that these are the true hours. So it does help provide a second layer of protection there in the event of an audit. A lot to cover in a short amount of time. A lot to think about, whether we explore certain pay plans, whether we reduce hours, whether we move some folks. I do want to open it up to questions if possible, if there are any, and see what we can provide clarification for you on. And Jessica, I'm not seeing, and perhaps I don't have access to that chat feature, but I don't see any questions listed in the chat box.
We do not have any questions at this point. Okay. If anyone has any questions, please type them into the chat box.
Perfect. We'll give it a few minutes and see if anybody types those in. But, certainly we don't want you to be reactive just yet, but we do want to plant that seed in your mind to start thinking about, are we going to be affected, and if so, who might that affect? I also do want to remind you that ASA has contracted with CESCO for free telephone and email consulting for HR-related matters. So if you have folks that you want to discuss, you can pick up the phone, call one of us, and you have access to any of the consultants, and let's talk about it, and let's make sure that we're getting you compliant. So that's a huge member benefit. And while we're also kind of just talking about the member benefit, you all do get a free handbook review on an annual basis that will look at your compliance from a federal and state perspective with your handbook policies. If you have not already submitted that or had it reviewed in the last 6 months by CESCO, go ahead and do that. Email it in to me. We'll be happy to take a look at it. There have been some recent regulation changes that are coming in the pipeline, or that have recently come through the pipeline, that require employers to update their policies, particularly from social media and confidentiality and complaint procedures and that sort of thing. So make sure that you are sending in your handbook. It does take a couple of weeks to get reviewed, but we will send you a nice little report that says, here's what your recommendations are. So do that. Let me see what else is on the wave path. You all may have heard about the OSHA transgender restroom issue or controversy. That is a hot topic, and that is something that you all need to be mindful of and think about how you will handle in your own organization, but also on particular job sites. OSHA is now stating, and the EEOC is backing, we cannot discriminate or refuse to allow somebody that may identify as a different gender or that may be currently going through transition of their gender. We cannot deny them use of whatever bathroom or sex bathroom that they may identify with. So it is a hot topic. It's a controversial topic. It is what it is. But be mindful that as we navigate through that piece, there may be increased complaints against harassment, hostile work environment, discrimination, that sort of thing. And I want you all to be very mindful of that and make sure that our employees are on good behavior and that they're not making comments or anything of that nature to other folks. So,
go ahead. Sorry.
I'm sorry?
I was just going to say we do have some questions now when you are
okay,
ready.
Great.
First of all, I will just let everyone know the PowerPoint, if it hasn't already been emailed to you, will be emailed to all of the attendees. So I know we have several people asking about that. The first question is from Chip Grimes. If the employee moves to hourly and doesn't keep a consistent record of the hours and we get audited, whose responsibility will this be?
Yes. Great question. So as the employer, you are required to maintain those time records for a minimum of 2 years. So it is your responsibility, it is the manager's responsibility to make sure that the employee keeps a time card and they're submitting it to you on a weekly basis. So you got to hold them accountable. That's the important piece, because if you do get audited, and the wage and hour investigator generally will rule with whatever the employee statement is, unless we have actual documentation to back that up. And as a reminder, Fair Labor Standards Act require us to maintain timekeeping records for at least 2 years. So you have to have the time cards there. So it's your responsibility to keep them and hold them accountable for that. Great question.
The next question is, could you please explain more about the bonus being included in overtime calculations?
Yes, absolutely. So if you have an hourly employee or somebody that is paid on a salary but is non-exempt, and they're getting a bonus that is tied to their performance. So, for example, Jamie, if you process this amount of paperwork or, get this project done on time, you a $500 bonus this month, whatever it may be. So basically what you have to do is look at, first and foremost, did the individual work overtime during the pay period in which the bonus was earned? If they did not work overtime, it's a non-issue. However, if they did work overtime and earned that bonus, we have to take that bonus amount and add it into the total monies earned that week, and then divide out the hours and get a new hourly wage rate. So in essence, their regular rate of pay will increase, as will their overtime rate of pay increase, and so we're going to owe them additional money. So, like I said, it's a case-by-case basis. I am happy to send Jessica our staff recommendation, and she can send it out to you all as well, a staff recommendation with good examples, how it works, with the bonus and overtime calculation. But just know that you basically have to do a separate calculation. You've got to take that additional monies earned, add it into the total wages that they earned that week, then divide it out by the total number of hours that they work to get the new regular rate of pay, and then be able to calculate the new overtime rate. So it's a little bit extra work, not terrible, but like I said, if they didn't work overtime when they earned that bonus, it's a non-issue. It just becomes a challenge when they actually work over 40 hours and they're earning that bonus. So great question.
Okay, the next question is, how does this apply towards salespeople?
Great question. Depends on how the sales individual, what their duties are, as well as are they inside, outside sales, or how their pay plan is structured. Some organizations have the ability of applying a separate exemption that would be a partial exemption from overtime if the individual is compensated with at least half of their total monies coming from commissions. So it may impact your salespeople significantly, or it may not have any impact at all. It just depends truly on the position itself. So if that individual wants to reach out particularly to me or to any of the other Sesco staff to talk about their specific sales positions, we'd probably be in a better position to answer that. But depending on their duties, depending on how they're compensated, they may be significantly impacted or they may not be impacted at all. So, great question.
Okay, the next question is, when are they supposed to make the final decision on all of these changes?
Yes. So as I mentioned, we didn't anticipate the final regulations until June or July of this year, but the Department of Labor has announced that they will release it sometime, hopefully before the end of May. So we will have an answer, final regulations, hopefully by the end of this month, and then they'll typically give you a 60, no more than 90-day implementation period. So you'll have a little grace period to get in compliance.
Okay. How many years should records be retained?
Tax records have to be kept for 10 years. Timekeeping records, I would say no less than 2 years, but to be on the safe side, I would say 3.
Okay.
Payroll,
I'm sorry, go ahead. I'm sorry, go ahead.
Payroll records, you probably need to keep at least 3 years as well.
Jamie, I'm not sure if this is a question for you. Do you know if this session qualifies for CPE for accountants?
I have not certified it with a CPE. I am happy to send you a overview or a table of contents that you can submit to your accrediting body and see if they will accept it. But no, we don't submit our programs for CPEs. We submit them for CEUs from an HR side. But you can get with me on a one-on-one basis if you'd like.
Okay. Do we have any final questions? Looks like all the questions we have in the chat box right now. If anyone has any final questions, let us know. Give it just a minute or so.
Sure. And like I said, it's a lot to think about. It's a lot to plan for. And we may be fine. You may not have to change anybody, or there may be some folks that, we significantly switch around. So give us a call. Like I said, you've got that access as a member benefit, so please use it. I'm going to go ahead and give you my direct telephone number in the event that you'd like to reach out. It is area code 804-931-6281. My email address is Jamie, Jamie, at Sesco, SESCO, SescoManagement.com. Also, if for whatever reason you cannot reach me or you'd like to call into the main corporate number, you have access to any of those consultants as well. That main telephone number is area code 423-764-4127. Just let them know you're a member of ASA and you need to speak to a consultant about wage and hour. So we're happy to help. I know it's a lot of information to throw at you all at once, but we want you to start thinking about it. And give us a call if you have questions or need additional resources. We're here to help. With that being said, I want to thank you for your participation this afternoon. And Jessica, I'll turn it back over to you.
Okay, thank you, Jamie, for your presentation. As a final reminder, please complete the webinar evaluation that was sent to you with your webinar materials and return it to ASA. Please join us for our next ASA webinar on June 14th entitled Driving Project Success, Keys to Improving Productivity. Thank you, everyone, again for your presentation today, and thank you, Jamie.